there are also many advantages in concurrent evidence from the expert's point of view. Many of them have told us how the process allows them to express their opinions without the inhibitions that come from the conventional method. They also believe that their opinion is given greater value. Many have told me how they now believe the inquiry is genuinely directed to identifying the truth, rather than a game controlled by the advocates, where the only objective is to win the case. Here's what some of them have had to say.
Having appeared in the courts over many years as an expert witness, I've experienced the formality of the adversarial system, but in my view, the reforms of the Land and Environment Court that encourage concurrent evidence create an atmosphere of informality, allowing an open discussion and a free flow of ideas. And I believe that this is an environment where the expert can more readily fulfil their primary responsibility to the court, to best inform the court based on their knowledge and experience, and to deliver the highest possible level of intellectual integrity in providing their evidence.
What concurrent evidence does is to provide an opportunity for the court to ask very specific questions of the experts, and for the experts to respond to those specific questions, so that there's no loss of court time in dealing with extraneous matters. It also provides the experts with an opportunity to address matters that might arise through the other experts' evidence, and to address those to the court, so the court can understand the attitude of each of the experts. It also provides a system by which the adversarial system is completely done away with in the court, so that people feel more comfortable in the way that they are responding to the court's requirements. And it also means that it provides a method by which the experts are able to give the court what the court would see as being relevant information to the decision-making that it has to undertake in the process. And in my opinion, it works well.
Concurrent evidence probably has its singular advantage, most important advantage, the fact that different experts can discuss in front of an informed audience exactly what are the merits or otherwise or disadvantages of any proposal, and offers an ability to be able to check one view against the other, to have competing views discussed, even debated, perhaps even with a little bit of heat that never hurts, and at the same time provide an informed commentary on a whole lot of aspects, not all of which each expert may have thought of in the first place, but certainly they are brought to have to think about them together. So as far as I'm concerned, it's a fantastic way of exposing both the advantages and the flaws of any development, and it offers a possibility for an independent judicial observer to actually make a decision based upon a real, in fact, or in a real-time debate about what is being discussed.
Well, in my experience, concurrent evidence can be a very useful tool for focusing on the issues that are determinative in a matter. I think it's important in those cases that the proceedings are tightly controlled from the bench. That way the witnesses remain focused. Otherwise, what can happen is if the lawyers at the bar take over the proceedings, then it's possible for them to become distracted and to divert off into areas that are not those matters that are most important to be determined.
Professor Mackay has emphasised the significance of the judge chairing the process. The role of the advocate also changes. They are required both to participate in the discussion and also ensure that the experts retained by their client adequately explain their position. They must also ensure that the opposing expert is effectively challenged. All of this requires additional skills. We've asked some advocates to tell us of their experience.
There are by now a whole host of benefits that are well known about the concurrent evidence process. Importantly, it shortens the hearing process, but at the same time permits the court to be fully informed of the entirety of an issue in one sitting. There are a couple of things that the concurrent evidence process is not, however, and importantly, one of them is that it is not the panacea for the lazy advocate. If anything, it's the absolute opposite and requires the advocate to be more fully prepared to deal with the entirety of the evidence that he or she may have to deal with in cross-examination. Because unfortunately, the witness that might previously have been, or the expert that might previously have been sitting there whispering in your ear to help, is now up there on the other side of the bar table participating in the process.
There's a real advantage, as I see it, in the process of having the experts giving their evidence all together once all the other evidence in the trial is in. This ensures that they're all focusing on the real issues as they have finally emerged at the end of the trial, rather than addressing the evidence in turn, as it were, on the run. And a real advantage from an advocate's perspective is that we can really use the collective processes of supplemental oral evidence in chief, cross-examination and re-examination of witnesses by, in effect, using one witness to aim a question at another witness, so that the whole process is proceeding all together, and that's a real advantage in being able to get the material out.
One of the advantages of concurrent evidence is that you can get the experts identifying their points of agreement and disagreement where they're being cooperative and professional. That enables the advocate to hone in on the particular aspect of the case where you're trying to get a concession or move the consensus of the experts as they're sitting together in the box towards the point of view you want to have. Of course, you have the disadvantage that your opponent might also wish to move it that way, and the judge will be seeking to try to get to the actual truth of the matter as well. But it works very effectively when you have that cooperation. There'll be other times when the experts don't all cooperate in that search, and in those situations you can use your ordinary skills as an advocate with a normal old-fashioned cross-examinations to credit, but you need to make it tailored, pithy and to the precise point that you are seeking to challenge the expert on. At the conclusion of your cross-examination, hopefully it's been effective, you can then turn to your expert or experts and say, well, what did you think of that? And that again is something quite extraordinary and unusual, but it's a very useful feature of the procedure because it enables everyone to express a point of view on that particular topic straight away and allow all in the courtroom, including the judge, to grasp what that issue is all about. One of the other things that this process teaches you, and I'm only in the learning processes myself, is how quickly the case moves as this process goes on. Instead of having cross-examinations such as with valuations that will take 1 or 2 days per valuer each, you'll get the whole of the 4 valuers, as we had in this particular example, over in a day and a quarter in the trial. That means your preparation has to be much quicker, everything is faster and more compressed, and you need to keep up with it. And again, that throws up a challenge of the system, but it means it gets the cases moving and it gets to the real heart of it far more quickly and, I think, in many cases, far more effectively.
You can also appreciate that because the judge sees the experts talking with each other, it is much easier to understand what they are saying and work out the evidence you will accept. Justice Lockhart, who first used concurrent evidence in the federal court, has this to say about the process.
Concurrent evidence was first introduced in this country by the Australian Competition Tribunal, of which I was president quite a number of years ago. Introduced by me as president and by Professor Maureen Brunt, an economist. It has been adopted since quite widely in Australian courts, including the Federal Court, of which I was formerly a member, and is in the process of being adopted by a number of international tribunals and by tribunals, including courts of other countries than Australia. The benefits to the judiciary, I think, are very clear. They enable the expert evidence to be commenced and completed in a shorter time frame than otherwise would be the case, and with less expense to the parties. But primarily what it does is it defines more precisely the true issues in the case, both matters of expertise and of law, and of course of fact. That also must assist, I think, the experts and does assist the advocates in the way they pursue their case. I found it to be of immense value, and I know the economists all went away from the court thinking it was a useful system because they felt they'd made a real contribution by being able to give their evidence without the necessary interruption of cross-examination at all points. And I thought when counsel got used to the system, they readily adapted to it, and it made full use of their expertise as advocates in cross-examining on the issues that really ultimately mattered. The only limitation I'd put upon the use of concurrent evidence is that one has to be careful, and this is a matter for the judge, of course, who hears the case, to ensure that not too many experts at once give concurrent evidence. There's no maximum number, that's for the judge. And that not too many fields of expertise, different fields of expertise, give their evidence at the same time. But again, this is a matter for the trial judge to determine as he or she thinks best. I found that I could take up to 9 or possibly 10 experts as economists in one sitting. Beyond that, it gets a bit unruly. But no doubt you could have 2 sittings of the experts if you wish to. But I emphasise it's a matter for the trial judge to adopt and in consultation with counsel. However, I've read and heard what the witnesses have said about this themselves for the purposes of this recording, and what advocates have said, and I agree with everything that they have said. I can only add what I have in relation to the judge's point of view. I do recommend the system to all people who practice in the law as a very useful system, saving costs and honing down the issues more completely and accurately.
Well, I trust this DVD has given you an understanding of concurrent evidence and how it works. It is a significant change, which you can see has many benefits. A moment's thought will tell you why the process has advantages. In our ordinary professional lives, if we had a problem involving a conflict of expert opinions, we would not set up a court case to resolve it. What we would do is arrange a meeting between the experts so that they could talk it through with the ultimate decision maker. For example, a life-threatening illness is often treated by a team of doctors who talk to each other about the best way of handling the problem, and a final decision is then made. If that is how professional people work, then why shouldn't courts work in the same way when problems involving experts have to be resolved? Many courts and tribunals have already adopted concurrent evidence, and I'm sure its use will increase. I hope this DVD will prove helpful to both lawyers and experts in making effective use of the process.